The Citizens Environmental Alliance was created to address the issue of farmland drainage and its impacts on the environment, and has collaborated with other like-minded organizations to bring you this conference. We wish to thank our conference collaborating organizations, Calling Lakes Eco Museum, Ducks Unlimited Canada, Eco-Friendly Saskatchewan, Last Mountain Lake Stewardship Group, Lower Capel Watershed Stewards, National Farmers Union, Nature Saskatchewan, Provincial Pastures, Provincial Interests, the Provincial Association of Resort Communities of Saskatchewan, Sierra Club Canada, Prairie Chapter, Saskatchewan Alliance for Water Sustainability, and the Saskatchewan Environmental Society. The organizers would like to acknowledge that the land on which we gather is the traditional First Peoples land and located on treaty land of the Plains and Wood Cree, Assiniboine, Saulteaux, Denisoulin, and Stoney people, and the traditional territory of the Dakota, Lakota Sioux, and the Métis people. In the spirit and intent of reconciliation, we sincerely recognize and acknowledge that Canada's Indigenous peoples are caretakers of Mother Earth and respective gifts of water, air, and fire. We all recognize and support that the First Nations people have a special relationship with the earth and all living things in it. Firstly, a few housekeeping notes for this panel session. Your mics will be on mute, and we'll be engaging with yourselves as we go along in the session. At the end, we'll ask you to hold all questions till after then. If you'd like to put a question as you think about it in the chat box, we'll be going from there and back and forth between that and allowing people direct questions from the floor, as we say. Today's session is on a panel of Prairie Wetland and Conservation policies. With me today are Amanda Cooper, the team lead for the Wetlands Unit in Alberta Environment and Parks, and David Hay, the acting director with the Drainage and Water Rights Licensing Branch in Manitoba. We're going to have a short presentation on each provincial policy or background, and then the question and answer session at the end. Firstly, I'll talk about the wetland policies in Saskatchewan. So a little bit about the history of the wetland policy in Saskatchewan. Even before 1988, the federal government, along with the provinces, recognized that wetlands were in great threat as early as 1981, and a great threat, majority from farmland drainage practices. There was then a working group in '88 that wrote a book regarding wetland loss in Canada, and then we had a federal policy come out on wetland conservation in Saskatchewan. As a result of the wetland conservation federal policy, we had the formation of the Saskatchewan Wetlands Conservation Corporation. The then had a 1995 provincial wetland policy developed by what we call SWIC. And one of the things that happened was Sask Water, at that time, the provincial agency responsible for licensing drainage, actually put in an implementation plan of that policy where permanent wetlands were not allowed to be drained. Semi-permanent could be with mitigation and other things, and then actually temporary and ephemeral were allowed to be destroyed without any consequences. In 2002, the Wetlands Conservation Corporation amalgamated with Sask Water and some Saskatchewan Environment Water Protection staff. That was when I was a wetland specialist and moved over to the Watershed Authority to sort of unite that environmental mindset with the drainage mindset of the Sask Water Agency. In 2005, and it seems like government has always got to be changing names as we go. Hard to keep up sometimes, but the Watershed Authority changed their name to the Water Security Agency. How do we compare the goals in Manitoba and Alberta? Well, both Alberta and Manitoba's goals are to conserve and protect managed wetlands because and recognizing the benefits they provide, not only to the environment, but also to society and the economy. In Saskatchewan, I'm afraid, especially around agriculture, the reflection is to it's to responsible drainage and no mention of wetland conservation as any part, and that's why we're talking about a new wetland policy for the province. In Saskatchewan, the wetland policy lies with mainly two agencies, the Water Security Agency, who's responsible for all aspects of allowing drainage, the diversion of water, and that sort of thing, but also the destruction of wetlands by agriculture and other methods. So they're dealing with that. Saskatchewan Environment is responsible for ensuring that the conditions contained in environmental impact assessments or minister's letter of determination for industry, essentially potash industry, oil and gas, that sort of thing leads to that implementation. There have been many attempts over the years, and when we got together as the Saskatchewan Watershed Authority, we tried to write an updated wetland policy, but I'm afraid there was a conflict or seemingly between the environment and development, and it was hard to get through that, and it was never resolved. Some of the examples in Saskatchewan of wetland mitigation in 2003, we had Highway 1 twinning, 71 acres of wetland habitat were destroyed, but fortunately at least 20.4 hectares were compensated for. So that was the start. The amount was questionable about what it did for us, but the bottom line was the recognition that it needed to be done. In 2010, the all-weather roadway between Stony Rapids and Fond du Lac, there was mitigation measures stated to ensure that no net loss of wetland function through the federal environmental assessment. And one of the greatest things that we ever seen was the city of Saskatchewan developing their own wetlands policy because they recognize the importance of wetlands to the people and the environment, and that was a great leadership thing done by City of Saskatoon. We also had highway twinning in McDowell in 2013, and there again, following with the other construction of the northern road, to have a no net loss of wetland function. We had the Albany Potash Mine, which had infill of approximately 70 hectares of land, of wetlands, and one of the things they talk about was that the mitigation plan would be developed and implemented after construction, which giving no guidelines or no provincial policy, what does that mean? And after the fact, and the Citizens Environmental Alliance is not sure that that is a good way to proceed, but we'll see. 2019, there was great amount of drainage in a drainage network called Blackbird Creek, 608,000 meters, about 608 kilometers of ditching with almost 1,400 hectares or 3,400 acres of wetlands being impacted. And the only thing they needed to do was have flow control. There was no other mitigation with that. So that's going backwards as far as we're concerned. And from 2014 to 2019, over 3,500 quarter sections of drainage were licensed in the province, which is about 13 times the size of Regina, and not 1 acre of wetlands restoration or any type of retention was a part of that approval or condition. So in the fall of 2020, the province, the Water Security Agency, actually proposed a drainage wetland policy and went out and started consultations. And at that time, they were saying that and this was for agriculture, that 50% of the wetland area in any watershed or network would have to be retained as a condition of licenses. They also proposed mitigating wetland loss by using both forage and pasture lands. We question whether you can have wetland function replaced by seeded forages or winter wheat or that sort of thing. We don't see that as an apples and oranges thing, but that is what they proposed. As a result of a lot of pushback from farmers, of course, the draining community, they stopped that policy. And currently, we don't have a wetland policy. There were 2 recommendations from the provincial auditor saying that WSA should have, the province should have one, and they continue to license drainage without one. And other than flow controls, we don't see much of anything involving retaining any values of the wetlands. The Water Security Agency set a date of 2024 to put a wetland policy in place, and that'll be interesting. And the consultations are supposed to start this year and run till next year. What's next? For the consultations, as I said, I think if you would like to be consulted or have some input into it, you should be contacting the Water Security Agency and talking about that. On Friday, as a part of this conference, we'll have an updated status of farmland drainage in the environment and wetland policies in Saskatchewan, and we'll be being more specific about what's going on in the province. And there's my contact information. Next, we'll have David talking about the Manitoba policy. You want to take it over there, David?
Thanks, Jeff. Just share my screen here. Are you able to see my screen?
Yeah, I can see your screen.
Okay, sounds good. So thanks for the opportunity to speak with the group this morning. We'll just jump right into this. So a little bit of background. The Drainage and Water Rights Licensing Branch administers the Water Rights Act. This is a piece of legislation that dates back to 1988. It states that no person shall control water or construct, establish, or maintain any water control works unless he or she has a valid and subsisting license to do so. So that's what the legislation that was changed in the fall of 2019 was modifying. The path that it took to get there, there was the Sustainable Watersheds Act, which was passed as a bill in June of 2018. And that really sort of set us down this path to look at a streamlined approach for the lower risk, lower impact type projects, enhancing protection for wetlands. It also modernized some of our inspection and enforcement tools, including enhanced offense and penalty provisions. Sometimes it's referred to as a grand bargain, where there was that streamlined approach for the class 1 and 2 wetlands, requiring compensation for the seasonal, the class 3 wetlands, to be able to pull this all together. So some of the other things, I'm not going to focus on that, but there were some exemptions that were put in place when the Act was written. Since it dated back to 1988, there was some changes to the application fees for the registration process as well as the licensing process. We added some flexibility to the downstream landowner sign-off requirements, as well as what I'm going to be talking about this morning is that new approach that requires compensation for the more permanent wetlands. So the two different types of authorization that our group provides, there's the registration process, and that really sort of encompasses those lower risk, lower impact type drainage projects. You can see the 7 different classes of works that we do detail out specification requirements. If the applicant is able to meet all of those requirements, they're able to work through seek their authorization. We would typically provide that authorization within a 14-day calendar day turnaround. The application fee for those types of projects is $100. If a project does not meet the criteria of a registrable project, or it is outside the scope of one of those 7 different classes, the applicant would need to work through this particular process. And so by design, it really focuses on the higher risk, higher impact type projects. It would encompass the drainage of seasonal or class 3 wetlands. And one of the things that I know the Provincial Auditor's Office had flagged a number of years ago was the wait times associated with our process. And so one of the overall purposes of this reform was to look at being able to shorten those wait times as the lower risk type projects are being fast-tracked through that registration process. The application fee for this particular process was set at $500. So looking now at the no net loss of wetland benefits approach, this was a new provision that was added in light of those changes that I talked about. The regulation itself that was built out then goes beyond to further describe the steps towards achieving a no net loss of these wetland benefits. It's also built in there the approach, a mitigation approach of avoidance, minimization, and at a last resort, compensation. The amount of offset required will vary depending on the type of restoration or enhancement work being done. So we use the Stewart and Cantrud wetland classification system. The class 1 and 2 ephemeral and temporary wetlands, these are allowed to have drainage conducted on those. That would be able to be captured through that registration process with the minor surface agricultural drains. The class 3 wetlands, those seasonal wetlands, those are the ones that require compensation. So typically how that would work is somebody would submit an application. We would work through the compensation aspect first. And once that aspect had been satisfied, then they would receive their license to be able to conduct the drainage work. The class 4 and 5 wetlands, the semi-permanents and permanent wetlands, those are not able to be drained. We had a previous policy, and that continues to this day, to not allow for the drainage of those wetlands unless under exceptional circumstances. So in terms of our delivery approach, it's really 3 distinct parties that are involved in the implementation of this concept. So on the left-hand side, we have Environment, Climate and Parks. That's our new name as of last month. Previously, we were Conservation and Climate, but our role itself was to administer the Act, the regulation, apply the no net loss principles. We were involved in conducting the wetland assessments, issuing the authorizations, as well as oversight of various agreements, funds, and reporting for the other players. And we also do provide literature and other information for educational purposes to applicants, as well as roll up the progress and the outcome reporting. There's a payment agency. You'll see that there is one of the options that individuals are able to use is basically simply just cutting a check to the payment agency. Their responsibility is to receive and manage the compensation funds. They need to have a tracking system to be able to account for those dollars, put in place an RFP type process to be able to then identify wetland projects that those funds that were previously collected can then be put in place for, ensuring appropriate standards and practices by the delivery agencies, which we'll get to in that third column, and report back to the department in terms of their overall actions on an annual basis. The individual delivery agencies, these deliver the wetland compensation or restoration projects throughout the entire province. They're involved in monitoring and follow-up. And you can see some of the potential agencies there. We haven't actually finalized that, but really that's the types of organizations that we're envisioning working with to be able to move this forward. So one of the things that we heard from stakeholders as part of the consultation process was that since the province itself does not have a wetland inventory, we needed to provide some further guidance to landowners to be able to enable them to determine wetland classification on individual parcels that they were looking at conducting drainage works on. And so what we ended up coming up with was really a document that uses a tremendous number of photos to be able to assist the applicants in determining their wetland classification, and then really sort of determine what authorization process they would need to work with, whether or not the wetlands that they're talking about are protected and not eligible for authorization of drainage, or really sort of where it fits. Some of the conversations that we'd had with those stakeholders was that they wanted it to be as easy as possible for individuals to understand, and yet enable them to get the additional information that they do require to be able to make informed decisions. So there's some mitigation ratios that were put in place as part of this wetland compensation scheme. Why did we select some ratios? Well, I guess that really provides that qualitative approach for determining compensation. It also accounts for a lag time or a risk of failure for some of these projects. It accounts for the functional losses of the restored versus the original habitat. Also accounts for losses as a result of projects going into being in perhaps less desirable locations compared to where the original wetland was. And I guess it overall does serve as a bit of a deterrent in terms of looking at undesirable land use decisions and habitat alterations. When we had done a bit of a jurisdictional scan, it was quite widely noted that compensation ratios are widely used internationally in a variety of applications, whether it be the U.S. Army Corps of Engineers. I know we looked at what Alberta was doing. In Manitoba, there was Manitoba Transportation and Infrastructure that they were using some ratios in terms of being able to offset for some of their highway projects that they were involved in. And it's also referenced within the boreal wetland context, as recently announced by the Provincial Ag Department. So in terms of the essentially 4 different methods of compensation that fall under sort of broad categories of restoration or enhancement. Restoration is restoring a previously existing class 3, 4, or 5 wetland. Enhancement categories are increasing the size of a class 3, 4, or 5 wetland, improving the benefits associated with the wetland, including an upland habitat component, as well as providing permanent legal protection of the improvement. And the last option under the enhancement category is providing permanent legal protection of class 1 or 2 wetlands. In terms of the ratio, it's either a 2-to-1 or a 3-to-1 ratio. The 2-to-1 ratio is applied in instances where we're looking at restoration or enlarging an existing wetland, and the 3-to-1 ratio is in those other categories. So if the project will result in the loss or alteration of a class 3 wetland, the compensation process will follow. First, the applicant needs to seek a license to drain that prescribed wetland. That application is in essence placed in abeyance, and at that particular point in time, the officer will inspect the wetland to confirm the size as well as the classification of the wetland, and the authorization will not be provided until that mitigation process has been completed. So the landowner is able to choose from 3 different compensation options. They have a payment option, a purchase option, or a perform option, or at the end of the day, they can also decide to walk away and not proceed with their drainage project and leave the wetland intact. So the next 3 slides breaks down those individual options. So the first is the payment option. In this particular instance, the funds are paid to the banker, and the applicant determines that calculation in consultation with our department staff. The payment is calculated based on the area of wetland impacted, multiplied by 2, multiplied by $6,000 per acre. So if we're just going to focus on that example in the bottom right-hand corner, if there happens to be a 2-acre class 3 wetland that is impacted, the required payment for that using that formula that I just walked through would be $24,000. So that's the first option that a landowner may look at selecting. The second one is an option that was added following conversations that occurred during the consultation process to address market concerns if the wetland restoration or enhancement project could be completed more economically than that first option, that payment option. So in order for that somebody to want to work through that, it would need, for that same 2-acre class 3 wetland, they would need to be able to negotiate a price less than the $24,000 that was previously mentioned. In this particular instance, they would have to work through that process, find somebody who had a project on their books, basically taking something off the shelf that had already been done, and for that negotiated price, be satisfied that they were being able to achieve a market-driven price that would be more economical than that payment option. And the last one is really a do-it-yourself type option or the perform option. Once again, the caveat on this is that the work must be completed prior to receiving their license to be able to go ahead and alter the seasonal wetland. This is very, very important so that we're able to demonstrate that one is actually upholding the no net loss of wetland benefits policy that the province had put in place. So in this particular case, the example of a 2-acre class 3 wetland, proponent may decide to enhance and protect 6 acres of wetland and upland habitat on their own property, assuming that they have a project that would fit in that particular category, and that is something that the landowner would be prepared to do. So I'm just going to wrap up sharing some of the results from the last fiscal year in terms of where we stood. We had received 807 new applications, roughly split half and half in terms of 343 being issued the sort of traditional licenses, and another half of them using that streamlined approach where the proponent would receive a registration certificate. The number of formal drainage complaints really hasn't changed. I guess it does fluctuate from year to year depending on whether or not we're having a wet year or a dry year. So you see that those numbers were down a little bit from past years. We also, as part of this proposal, decided to increase the number of compliance checks that staff are able to do. And so we do typically complete that in the spring, early summer, to ensure that we go back to a minimum of 10% of project authorizations, just to make sure that the work was conducted as specified. And I guess of note for this particular group, in terms of the wetland compensation piece, we only had 2 projects that proceeded in terms of providing wetland compensation. One had elected to use that payment option, and they cut a check to the banker in the sum of $24,000. And one individual decided to use the perform option and had provided a 10-acre project to be able to provide the required compensation for their drainage project. We also had issued a number of offense notices and charges under the Act, 25 warnings last fiscal year, 4 orders to address unauthorized water control works and ongoing impacts. And one of the other things that we were able to do is to use the certificate of debt process to ensure that the department was able to ensure cost recovery of outstanding orders. In the past, we always didn't have as much success. In this particular instance, we're able to use the courts to be able to garnish wages, seize assets, or attach the debt to properties through as part of the title itself, so that when the land is sold, we are able to recover those costs. So that's the end of what I was wanting to share. You can see my contact information, email address, and phone number. And at this point, I will turn it back.
Thank you very much, David, for that informative presentation. Lots to think about. Next, we'll have Amanda Cooper with the Alberta Environment and Parks Department talking about the Alberta policy. Go ahead, Amanda.
Thanks, Jeff. Can you see my screen?
Yeah, we can see it fine.
Perfect. So yes, thank you very much for having me today. I'm Amanda Cooper. I'm the team lead for the Wetlands Unit with Alberta Environment and Parks, and I've been invited today to discuss the Alberta Wetland Policy. There we go. So I'll just give you an overview of the policy. So in 1999, the department introduced the Water Act. The Water Act states that any activities within a water body require an authorization, and the definition of activity is quite extensive. It's placing, constructing, operating, maintaining, removing, disturbing works, maintaining, removing, or disturbing ground, vegetation, or other material, or carrying out any undertaking, including but not limited to groundwater exploration in or on any land, water, or water body that, and then has a number of items there. So it's quite a large definition. And basically, if you're impacting water or a water body in any way, it states that you will require some type of authorization underneath the Water Act. So the Water Act defines a water body as any location where water flows or is present, whether or not the flow or presence of water is continuous, intermittent, or occurs only during a flood, and includes but not limited to wetlands and aquifers. One thing that the Water Act did not do was actually define what are wetlands. So that's one of the sort of really important parts about the Alberta Wetland Policy, is that it actually defines what are wetlands. So we know what water bodies are, so that we can apply that requirement for authorization underneath the Water Act. So in 2008, the Alberta Water Council put together a report on recommendations for a new provincial wetland policy. The department conducted stakeholder engagement from 2010 to 2012 and wrote the 2013 new wetland policy for Alberta. And this is a cabinet approved wetland policy. Not all of our policies are cabinet approved, but the wetland policy is cabinet approved. So in 2000, we gave some time for education and additional stakeholder discussions. And in 2015, we implemented the wetland policy in the white area of the province. So that's the settled area. And then in 2016, we implemented that in the green area, so our crown land. So in Alberta, that's mostly in the northern part of the province. So the goal of the Alberta Wetland Policy is to conserve, restore, protect, and manage Alberta's wetlands to sustain the benefits they provide to the environment, society, and the economy. There are 4 outcomes of the policy. The first is that wetlands of the highest value are protected for the long-term benefit of all Albertans. The second is wetlands and their benefits are conserved and restored in areas where losses have been high. 3, wetlands are managed by avoiding and minimizing negative impacts, and where necessary, replacing lost wetland value. And wetland management considers regional context. So as I said, the Water Act did not define what wetlands are, and so that's an important component of the wetland policy, is actually to put a definition around what are wetlands and what we are considering as water bodies that require an approval. So the definition is land saturated with water long enough to promote wetland or aquatic processes as indicated by poorly drained soils, water tolerant vegetation, and various kinds of biological activity that are adapted to a wet environment. And we have a Alberta wetland classification system because we have both peatlands and mineral wetlands. The Stewart and Cantrud wetland classification system didn't quite identify all of the wetlands, and then the Canadian wetland classification system sort of didn't work for all of the mineral wetlands that we had. So we kind of combined them and created our own Alberta wetland classification system. So when we identify wetlands, these are the 5 categories that we use. So there are bogs, fens, swamps, marsh, and shallow open water bodies. So the Wetland Mitigation Directive, and this is how we manage wetlands in the province, is through avoidance. So it's this upside down triangle. So avoidance of wetland impacts is the preferred response. Any applicant who is going to impact wetlands has to go through this mitigation hierarchy and see if their project can avoid impacts to wetlands first and foremost. If they cannot, then they must minimize those impacts. So where avoidance is not possible, proponents will be expected to minimize. So an example of this would be like a road project, for example, if you're constructing a road rather than, impact going through the wetland in the middle of it, you put the road on the side if you can't completely go around the wetland. And then the last little triangle is replacement. So as a last resort, where avoidance and minimization are not feasible or ineffective, then replacement is an option. Wetland replacement, applicants can fulfill that through 3 options. The first one is to purchase credits, and there's a little asterisk there because that actually hasn't been fully developed as a program option right now. The second is make a payment to the in lieu fee program, and I'll talk a little bit more about that, but that's our wetland replacement program. And then number 3 is to undertake permittee responsible replacement. So that's the applicant restores or constructs wetland area on their own property or another piece of property that they have access to through their approval. So when we talk about wetlands and their values, what we're talking about is their wetland function. So the wetland policy really identified that wetlands are unique in the landscape and not all wetlands are equal. And so rather than looking at wetlands for the area that they occupy, we are looking at the functions and the overall value that they contribute to the specific watershed that they're in and the location within the province. So to do that, we use what we call our rapid evaluation tool. It's called ABRET for short, so it's the Alberta Wetland Rapid Evaluation Tool. And we use this tool that was developed in partnership with Dr. Paul Adamus. And there are a number of questions that need to be answered. There's approximately 76 questions that evaluate biodiversity, water quality improvement, flood reduction, human value, and it factors in abundance as well of that wetland. And then the model spits out a wetland value category. So A value wetlands are considered to be a high value, B are moderate, C is moderately low, and then D is a low value wetland. Just because it's a D value wetland doesn't mean it's not an important wetland. It just, for the purposes of evaluating it, it just has a lower value than a high value. So we take that information and we assess that against the wetland replacement matrix. So the wetland replacement matrix says that if you're impacting a wetland of a specific value, then it needs to be replaced. We assume that wetlands are being restored at a D value. And so that is why that box is highlighted there. So if you're impacting an A value wetland, for every hectare of A value wetland that's being impacted, 8 hectares are required to be replaced. And then for a D value wetland, if you're replacing a D value, then it's just a 1-to-1 ratio. So I'll take you through an example of a assessment so you can sort of see how this matrix is utilized. So if we do need to use that replacement, we need to determine that lost value of wetland area through the ABRET model. So in this example, let's just say it's a C value wetland. So we know that the applicant will have to replace at a 2-to-1 ratio. And we determine the replacement fee based on where the impact is happening in the province. The province is divided into 21 different assessment units, and depending on land value, historical loss of wetlands, we have a in lieu rate. So it's $1 per hectare. So in this example, I've just highlighted number 13 on the map, and so any projects, the base rate is $17,700 per hectare that is required to be replaced. So putting all this information together, say 1 hectare of wetland is being impacted. It was assessed to be a C value wetland. We know through the replacement ratio of that mitigation matrix, it's a 2-to-1, and that the project falls within the relative value assessment unit number 13. And so that's a $17,700 per hectare replacement ratio. So if we take our 1 hectare times the 2-to-1 replacement ratio, 2 hectares need to be replaced. And then you take that 2 hectares times the 17,700. So the total replacement fee for that specific project would be 35,400. So we implement the wetland policy through a number of operational directives. The first one I had mentioned is the wetland classification system, which defines all of the wetlands. The second one is the wetland identification and delineation directive. So that's a directive that identifies like a step-by-step process on how to actually identify and delineate the boundary of a wetland in the field. Then we have the Wetland Rapid Evaluation tool. So that's that ABRAT tool that assesses all of the information that you've collected up until that point. And then we have the Wetland Mitigation Directive, which sort of goes through the mitigation and replacement and or that permittee responsible replacement. And then all of that information gets put together in a wetland assessment and impact report or a form depending on the project. All this work is undertaken by authenticating wetland professionals. So these are individuals who are part of these 10 professional organizations in Alberta. There's a common practice standard that has been developed with the 10 professional organizations and the government of Alberta. The organizations are responsible for assessing and ensuring that their members meet the requirements. This allows for a transparent process of who can undertake wetland assessments and who can sign off on and like stamp and certify that the work is complete. And this provides assurance to the landowner as well as the department on knowing that the work is has been completed by a professional. So if a wetland replacement fee is paid, the money is it's collected and directed to the department through the Wetland Replacement Program. The Wetland Replacement Program aims to reestablish wetlands in partnership with Albertans by providing resources for collaborative replacement projects across the province. We work directly with municipalities and nonprofits to restore wetlands and construct wetlands directly within the watersheds where wetland impacts have occurred. We work and provide funding for two types of wetland replacement. The first is wetland restoration. And so that's returning the natural or historical area and functions to a former or degraded wetland. The second one is wetland construction. So that's creating a wetland area that was historically upland or non-wetland area. And so perhaps has been a shift in hydrology, it changes on the landscape, et cetera, and we can construct a wetland or convert a dugout, for example. So we partnered with Ducks Unlimited underneath our interim policy, and up until the province took over the wetland replacement program in 2018. Ducks Unlimited has completed over 700 projects and replaced 3,280 hectares approximately of wetland area. And they have provided and or funded projects equaling 47.2 million in funding. With the wetland replacement program, as I said, we had just started collecting the replacement fee in 2018 for the department. And so the wetland replacement program just started in 2020. So we've only had 2 years of projects, but we've completed 16 projects in those 2 years. We have replaced 286 hectares of wetland, and we've provided 7 million in funding. Here's some helpful links for some more information about the Alberta Wetland Policy and the implementation and directives, as well as if you have any specific inquiries with regards to the Wetland Policy, you can email aep.wetlands@gov.ab.ca. And the Wetland Replacement Program, if you're interested to know more about the Wetland Replacement Program, the email address is aep.wetlandreplacement@gov.ab.ca. And I will hand the presentation back over to Jeff. Thank you.
Yes, thank you very much, Amanda. That was a very informative presentation on Alberta's wetland policy, and it's good. We've got a few questions that some you can both handle and some individuals. The first question, and this will be for both you, and David could go first, is how is the upland surrounding the wetland considered in the policy? In that most likely, you know, if there's adjacent native prairie or native aspen parkland, is that factored in any way. David, would you like to take that first?
Yeah, I can certainly provide some initial comments. I guess really that is dealt with on an individual sort of application by application basis in terms of what makes sense. Obviously, not wanting it to be the focus of the project itself, but certainly, you know, we are interested in understanding sort of how both pieces really tie together, and so we don't have a restriction in terms of, you know, where one, you know, the wetland is and where how much upland there can be, but certainly I would just say that, you know, it's been dealt with up until now on a case by case basis.
Okay, thanks. And Amanda, what about in Alberta?
Well, with the Water Act, it's very specific to water bodies. So if it's upland area, then it really wouldn't meet the definition for water body. It is considered as part of the overall impact and just sort of that cumulative impact of the project. Through the wetland replacement program, when we are putting wetlands back, it is a consideration to ensure like long-term protection of that wetland. And so it certainly is a factor when we are discussing replacing wetlands and working with municipalities, and having a buffer area is certainly important for those benefits long-term.
Yep. Thanks. Here's a straightforward question. This one's for David. Does Manitoba search out illegal drainage? Do you go looking for it, or is it through a complaint basis?
I would say it's really both. Some of it does come forward via written complaints that we receive from individuals. But, you know, certainly there's also instances where water resource officers are out driving around. They may be doing a site inspection or maybe looking at another project. And through those activities, they may undercover unauthorized works as well, and then reach out to the landowners to ensure that they're brought into compliance.
Do you want to have a go at that one, Amanda, and give us Alberta's perspective?
Yeah, so we have a like a 1-800 hotline number that complaints are received through. So we, our compliance officers don't like actively seek out complaints, but we do receive them through that 1-800 hotline number, and then our officers do respond to those complaints. They do have the ability to do compliance sweeps. We haven't done a compliance sweep for like specific to wetland drainage to date, but we have responded to a number of complaints that have come in through the department through that 1-800 number.
Okay, good, thanks. This one's directly for David, very specific. Is there a formal contract relationship between ECP and watershed district groups? And what role does the watershed district organizations have in working with the wetland policy?
So I guess that's something that hasn't yet been built out in terms of these arrangements with what we term the approved service providers. But that is the long-term process that we do envision for those watershed districts that are interested in participating in this approach. They would obviously sign that agreement, and that would enable them to be able to deliver projects on the landscape as they identify them.
Okay, good. Next questions regarding something that we're seeing more and more in Saskatchewan, and that's tile drainage. In Manitoba, why is tile drainage considered low risk? Whether you remove a wetland by draining it from the bottom or overland, it's still gone. Also, when wetlands are drained using tile, it is also done to pull salts, or does pull salts down and out of the farm soil later. What's done to mitigate the effects of those salts on the water quality of the receiving lands or on other waterways?
So the only tile projects that are able to move forward in that fast tracked or that registration process, they need to meet those requirements that are spelled out within the water rights regulations. So it's not all projects that would, if there was a seasonal wetland that was being impacted, that would not be eligible for registration. So it would need to take that longer term approach. There's a setback that projects need to be 50 meters back from the seasonal wetlands. But that's how we handle it in terms of dealing with those two different types of approaches. Once again, these things are done on a case-by-case basis to ensure that there aren't unintended consequences.
Okay, good. For Amanda on the same question, is tile drainage prevalent now in Alberta, and does it work into your policy, or is it the same as any overland drainage?
Yeah, I think that there has been an increase in the amount of tile drainage that we've seen in Alberta in the last few years. Tile drainage is considered drainage, and it is considered a wetland impact. And so if you were impacting a wetland through the installation of tile drainage, you would be required to meet the requirements of the wetland policy, which would be replacement as well. So you'd have to compensate for that lost wetland value.
Good, good. Another question for you, Amanda. The replacement dollar cost per hectare seems fairly low. Do we know the real cost of replacing or restoring wetlands, and where did you get the number?
Yeah, so the number, I can't say that I was part of developing it. It was developed before I was part of the department, but it came from a number of factors, including land value costs, so how much it would cost to purchase land and to undertake the actual construction work of the project. Through implementing the wetland replacement program, we have sort of, realize that it is costing a lot more than what we're replacing. On average, it's around 80,000 a hectare for wetland replacement. So the fees are, they're not exactly aligned. However, we need to balance the ability for individuals to be able to make that payment versus, the cost of the project. So it's a balancing thing.
Right. And follow up with David then, where did Manitoba get the idea that $6,000 an acre was the magic number?
Yeah, so when we built out this, we had relied a lot on the jurisdictional scan that we used, and went back to various parties to come up with, sort of where that number, should be. That was sort of the also considering Manitoba partners and what it was costing them to do that type of work when the policy development work was done in 2018. I know that we had also looked at some sort of inflationary clause, but we were urged to just set that fixed amount, and in the event that it needs to be indexed due to inflation, that we come back with a regulatory amendment to be able to accomplish that.
Good, simple. Question for Amanda. You mentioned that you worked with municipalities on the wetland policy issue. Did it include urban municipalities, or how did that go that way?
Yeah, all municipalities were part of the consultation process. Also with the Alberta Water Council, there's a number of stakeholder groups that are representative on that council as well that put forth the recommendation for the wetland policy. And through the wetland replacement program, we work directly with municipalities. So we're meeting one-on-one with municipalities, like all municipalities across the province. So that includes large urban areas and rural municipalities, towns, etc., are all eligible to participate in the program.
So are urban municipalities subject to the regulations for drainage in Alberta?
Yes, it's across the entire province. So if it's a wetland that's being impacted, you're subject to the wetland policy, regardless of its location.
So City Calgary's have to abide by the regulations in Alberta? Good.
Yes, if they are impacting wetland, development areas, City of Edmonton, City of Calgary, they're still developing and they're still expanding, and their properties are subject to wetland policy.
Oh, good. David, do you want to handle that from a Manitoba perspective? Were the urban municipalities involved much, and are the laws concerning wetlands and mitigation also pertain to urban municipalities?
Yeah, so in Manitoba, municipalities themselves are excluded in terms of the drainage works and needing separate authorization. However, if they do impact wetlands, that exclusion does not apply. So they would need to work through the same process as any other proponent would.
Good. As far as I know, in Saskatchewan, the urban municipalities aren't required to follow that, which is interesting. Amanda, question for you. How did Alberta develop such a robust wetland policy? And was it really the oil field industry that created the push for the wetland policy, comprehensive one?
I wasn't with the department when the policy was created itself, so I can't answer the second part of that question, but all of our stakeholders, I guess, are all environmental stewards. And so we had an interim wetland policy that was in 1993, and it was very ineffective, I would say. It just sort of focused just on marsh wetlands within the White area, and it didn't cover the whole province, and it was sort of not implemented and applied very well. And so through the Alberta Water Council, again, which has representatives from many stakeholder groups, including our oil and gas industry, provided that recommendation to the department for a more robust and comprehensive wetland policy. So it was the department created the wetland policy based on that recommendation from 2008.
Okay. Good. One of the questions again about tile drainage. There's no setback requirement for tile draining on adjoining property, meaning you can be, I don't know, 10 feet away from the adjoining property and have an impact on the groundwater in the adjacent land. Does Manitoba have a setback, or how do they deal with tile drainage and the effects to land next to the tile drainage that's not owned by the guy doing the draining?
Yeah, that is in fact the case. I guess the way we would deal with that is if something had come up as a result. One of the clauses, licensing conditions within both the registration certificates as well as the water control works licenses does require modification of a project to be able to address those unintended consequences of those impacts that are brought to the attention of the department after the fact. So that's how we would deal with those types of situations.
Yeah, tile drainage is new to Saskatchewan, but been a while in Manitoba, but still working out the kinks, it sounds like. So that's good. On a Manitoba, another perspective, David, does the no net loss policy apply to class 1 and 2 wetlands, or only class 3 wetlands?
No, so yeah, so the ones and twos, there's no compensation required for those, and that, as I sort of started making the reference to that grand bargain, that was where the province landed in terms of, we would still continue to provide authorization for the ones and the twos. And I guess really in retrospect, if you look, the vast majority of those ones and twos are already, or in most instances, have already been drained. But this, what I talked about, was only for the class 3s.
Okay. This person must have been from Alberta, because they mentioned that they thought the Alberta wetland policy doesn't extend to ephemeral wetlands. Is that true, Amanda?
That's true.
or is it?
Ephemeral, yeah, that's true. Ephemeral wetlands are not considered to be wetlands. However, they are considered to be water bodies. So you still require a Water Act approval to impact ephemeral wetlands. You just are not subject to the wetland policy, which requires that replacement of that lost area.
Okay, good. Does Manitoba only restore class 3 and up wetlands for compensation, or do they do like Alberta and restore a higher ratio of 1 and 2 wetlands?
No, we don't differentiate in terms of the compensation ratio, but somebody would be able to look at doing work on a say a class 1 or a 2 in terms of the permanent legal protection of those areas. So that is sort of how the 1s and 2s would integrate into our wetland policy.
Okay, good. Question for both of you. What do you look about development in wetlands requirements for in cottage country, in resort communities or subdivisions and that sort of thing? Do you want to take that first, Amanda?
Sure. So just to make sure I understand the question is, how does the wetland policy apply in like cottage country, residential areas, development around lakes type thing?
Yeah, subdivisions, yeah.
Yeah, so the wetland policy applies sort of the same across the province. So if there is a development that is going into like adjacent to a lake or whatever, then the wetland policy would apply. So we do recognize that wetlands, that lakes do have wetland fringes, and so there may be a certain portion of that lake, for example, that may meet the definition of a wetland, and so that would be subject to wetland policy. The lake itself being a water body, you have to go through the Water Act process as well. Many of our lakes are claimed by the Crown. So those are your higher class wetlands, so 4s and 5s, where the Crown actually asserts ownership underneath that bed and shore of those wetlands. And so there's another piece of legislation that gets sort of triggered when that happens, and that's our Public Lands Act. But as far as like, say like back from the lake and not within the lake itself, but those cottage developments, acreages, new subdivisions that are developing, say a 3-acre parcel of land, they're all subject to wetland policy requirements if they are impacting wetlands.
Sure. So it sounds as though whether it's urban or recreational, the policy applies across the board. So
That's
it
right.
must apply in the north in the forest industry as well, I would take it.
Yeah, so essentially, if you are impacting a wetland, regardless of that impact, if it's a housing development, if it's, I don't know, a water treatment facility, if it's a pipeline, if it's, oil and gas well pad, it's subject to wetland policy requirements.
Okay. What about in Manitoba? You have lots of cottage country there. Does the policy apply to subdivisions in recreational areas? David?
Yes, it would. I guess the other thing that I should mention is it would also be dependent on the development. So, some of the subdivisions would move through our process, and we would look at the wetland component if there was one. Some of the others would probably end up being that they would be much larger in scope. They would need to get approval through the Environment Act licensing process. And so the proponent would need an Environment Act license. And so those comments largely relate to what I would term as agri-Manitoba. We also have the boreal wetland policy in sort of non-agri-Manitoba. And so that would be dealt with through a separate policy.
Oh, so you have two policies, one for the boreal forest and one for
Correct.
southern out of the,
Yeah.
And they differ substantially, or they're a lot the same?
It really
what you
depends on
essentially
it
gave
really
us today
depends on
was,
how you look at it. It was developed after our policy, and so our policy informed some of their efforts, but that is now currently led through the separate Department of Natural Resources and Northern Development.
oh, okay. And so essentially you talked about what's happening in southern Manitoba in the farmland more so than in the forest, right?
Yes, that is
Okay.
correct. That is the component that our branch is responsible within Environment, Climate, and Parks.
Yeah. So there's a question here, and it sounds like it's for me. What are the reasons that Saskatchewan hasn't developed a wetland policy, but Alberta and Manitoba have? Well, from my perspective, and I was internal to government for over 35 years, and it was the age-old case of the economic development with the environment and the balance and seeking that balance, and it's just not that easy to come to. In Saskatchewan, one of the things we lack is a provincial wetland inventory. So although we know there's been a lot of loss and you can see it continue losing, is it really that great an issue, in the western side of the province versus the east central where we are and that sort of thing. So it's not easy, and until agricultural producers and the environmental community, urban people, industry all sort of sit down and come up with an agreement or decision on that everybody can live with. Not that everybody necessarily happy with, but everybody can live with. We're just having difficulty with that. Okay, next one, Amanda can take this one. Are Manitoba and Alberta pursuing remediation for compliance on older historical drainage projects? As Saskatchewan says they're going to.
Older than, I guess it depends on how old and how historical we're talking about. The wetland policy is a go forward policy. So once it was implemented in 2015, it's go forward. So it applies to projects from 2015 forward.
So you could actually say that it's grandfathered, everything pre-2015's grandfathered. That's the basic?
Well, the Water Act was implemented in 1999, and so if we are meeting that definition of an activity prior to wetland policy implementation, right? Like there's there are different dates there, and so it's not grandfathered in because you could still be conducting an activity under the Water Act, and the Water Act is the legislation that we enforce. We don't enforce wetland policy, if that makes sense. But the policy is just applied for projects from 2015 moving forward, and whether or not it was a non-compliance with the Water Act, then the compliance department would assess that and determine. One of the options that we have through compliance is reclamation. And so if the department did make a determination that that project was in non-compliance with the Water Act, then they could require some type of remediation or reclamation on that project.
Okay. What about Manitoba? Do you have a grandfather's clause, or what are you doing with older historic drainage networks?
Yeah, it would really depend on sort of how old we're talking about, or when that work was conducted. So oftentimes we will go back and look at past orthophotography to inform ourselves on that. If in the instance, we would look at the date of the application. So if somebody applied, which we wouldn't have any of these in this particular case, being that it occurred in the fall of 2019, but anything new would be subject to the current policy in terms of requiring the mitigation. But if there was something that happened prior to that we were able to have a look at and wanting to insist on ensuring the project comes back into compliance, we would deal with those on a case-by-case basis.
Good. Okay. in Saskatchewan, we have drainage associations like the Conservation and Development Authorities, which assist in major drainage projects. Do you have like that in Alberta and Manitoba? Or how are large drainage projects actually handled?
We do have drainage districts in Alberta. There's a drainage act that enables drainage districts to exist and to operate. Very large drainage projects, we would work with the drainage district. Most of them are already established, so it's not like we have new drainage districts coming on board or anything like that. But regardless, if there are impacts to wetlands that are happening in a project, they are subject to wetland policy. So there's no sort of exemptions that are applied to that. So.
But the drainage districts, they are similar to then the irrigation districts, in which they would handle a lot of the infrastructure and coordinating the licensing and that sort of thing. Eh?
That's right. Yeah.
Okay. What about Manitoba? What do you guys have?
Yeah, we wouldn't have formal drainage associations per se. Some of the, and I guess it really comes down to the, the definition of a large drainage project. Some of those would be able to receive authorization under the Water Rights Act. If it was a very, very large project, it would need to be handled through the Environment Act.
Okay. Good. Well, that pretty well wraps up the questions from everybody. I'd like to thank Amanda and David for coming today and being on and providing a great insight into what's happening in our sister provinces on both sides. If you'd like to find out more information about farmland drainage and the wetland impacts, you can see some of that on the Citizens Environmental Alliance Facebook page. As everyone says, please like, follow, and share. You'll also be able to find the recordings from this and previous conferences on the Citizens Environmental Alliance YouTube channel.